What does it mean when your divorce goes to mediation? That means that you are hiring a neutral third party who doesn't have anything to do with either of the parties, doesn't know them, isn't connected with them, but who is carefully trained in dispute resolution. And this neutral is going to help you find solutions, whether you're represented by lawyers or whether you're not represented by lawyers. In divorce, does mediation mean settlement? Not necessarily. You may mediate for several days and then get a settlement, or you may mediate for a few hours and get a settlement, or you may mediate for a few hours and someone gets angry and leaves despite everyone's efforts to hold them in their seat. So it's just different in every case, but the vast majority of cases will find a settlement. Should you have your own lawyer at mediation? In a complex case, you absolutely should. It's important to have a well-trained, experienced lawyer with you because it's easy to make mistakes and it's easy to be taken advantage of. If you have what would be considered a garden variety divorce, a simple set of circumstances, perhaps one home, a couple of cars, a retirement fund, simple children's issues, you might not need lawyers at the beginning, but you will need them in the state of Tennessee at the end because the mediator cannot draft your settlement documents. So an experienced lawyer will be needed, maybe two, depending on how everybody feels about using a single lawyer, to draft those documents and to guide you through the court system to get your divorce. Should you ever mediate with anyone who is not an experienced divorce lawyer? I think this is a tricky question. I think the vast majority of family law cases are better served by mediators who have been in the divorce trenches in the courtroom and who have experience with actual clients in the realm of divorce. It is a different animal. People behave differently. It's a very stressful process for people during this time, and they don't always make decisions like they normally would. So having an experienced lawyer with you can help guide you out of the trenches. However, there are cases when you might want someone other than the divorce lawyer who is also trained as a mediator to mediate for you, or you might want the trained divorce lawyer mediator along with another mediator called co-mediator who might be, say, in the psychological field or in the child psychological field, depending on what your issues are. And sometimes having someone highly experienced in that other discipline is really nice in a problematic case. Prior to mediation, when you are a lawyer representing a spouse, what do you say to your client in your pre-mediation strategy meeting? I think this is different for everyone. Obviously, what gets talked about is very case and fact driven. However, there are a couple of guiding principles that need to always be discussed. And one is that there is no perfect solution to any single case. There are a realm of solutions, and that realm of solution comes from what a court might do, in particular the court in which your case is sitting, might do given what the facts of your case are. So setting careful parameters about sort of a best case scenario settlement and a worst case scenario settlement, I think is really important because those two exterior boundaries to the thought process are what will guide you and your lawyer if you have one with you. What is a divorce mediation statement and what should be in it? I have mixed feelings about this, and here are those mixed feelings. Sometimes, depending on the emotion in a case, when your good lawyer does a detailed mediation statement which sets out what all the facts are in your case, all the assets and liabilities are listed, the child-related issues, and spousal issues are all identified, as is a proposed outcome, a proposed settlement of the matter. Sometimes people who are not in good emotional places can get really stuck in what that lawyer is recommending in that written mediation statement to a mediator. And so lawyers have to be very careful, because one size will not fit all cases. If there is a real emotional element to a case, then the mediation statement needs to be tailored to that, with the important caveat that I previously mentioned, which is there is no perfect settlement. And everyone has to understand that just because a lawyer sees the case in a particular way at the time of the writing of that mediation statement, that doesn't mean that by the time we are actually in the mediation process, that other facts don't come out from the other side that might affect that. So lawyers have to be careful to craft their mediation statement for me in a way that they think is helpful given their case and their facts and their client, while also making sure that those clients know that just because it's in a mediation statement doesn't mean that that's the final word.
Suzanne, let me ask you a follow-up question on that. Let's speak specifically about emotional elements, and possibly even where a party has been a victim of abuse. Do you see that it's more cathartic or less productive to include a very detailed description of the emotional aspects of the marriage, to understand the parties and where they come from to that point of mediation?
I think that's an excellent question, and that too has to be determined by a good lawyer on a case-to-case basis. Some people, particularly those who have been victimized by abuse, are actually triggered by seeing what has happened to them laid out in the narrative format that we lawyers and mediators love to use. If that is who your client is, then obviously that's not a case to lay that out in great detail. You're going to want to skim around that and probably pick up the phone and talk to me about what has gone on. I can take down a timeline of those terrible events on a phone call, just like I can read them on a piece of paper. And if you have a client easily triggered, then that's a better way to go about that. However, there's also that other client who has been through perhaps the very same abuse. And for them to see it written out in narrative format makes them feel like they are finally being heard and they are finally being able to tell, because there's a lot of secrecy around abuse. Often people who are badly abused are surrounded by people who have no clue that that person is being abused, including ministers and Sunday school teachers and best friends and sisters and mothers and fathers. So a lawyer has to be careful about who their client is. It's not a one-size-fits-all. And it's certainly not one of those things where you can just assume that it's a good thing to tell all. You have to be very, very careful. Err on the side of being conservative. What is a divorce marital balance sheet? The divorce marital balance sheet is an incredible tool, particularly when we do it in Excel or a program that will self-calculate for us, that will let us lay out all of the assets and liabilities, including their values, and even identify in separate columns those things that we know under Tennessee law are what's called separate property, those things that were brought into the marriage, that were given to a particular person as a gift, or that they have inherited. And if it does the math for us, then we can very, very quickly divide estates in various scenarios and show the percentages of those divisions, and it's an extremely effective tool. This is the single most important piece of paper, electronic piece of paper, that I can be given. Nothing else matters as much as a marital balance sheet if it's a typical divorce case. Having it ready ahead of a mediation saves thousands and thousands of dollars, but sometimes it's just not possible. Sometimes documents are still being gathered, and we actually start the mediation by crafting one of these. So it's not a right or a wrong thing. It's certainly a circumstantial thing, but if it can be done prior to a mediation, it is an incredibly useful, time-saving tool.